Thank you for joining us today. We're going to spend some time today talking about the E-2 visa options where the investment amount is low or for risky E-2 cases. A few things before we get started. Some of you may know that this law firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is here on an E-2 visa, so is very familiar with what you are going through. This firm is a full-service immigration firm, but we focus primarily on E-2 visas. We've processed hundreds of them, and we typically process E-2 visas that are higher risk, meaning kind of lower investment amounts. We've processed at consulates around the world, but our primary two consulates are Toronto and London. We will continue our webinar series, doing at least 2 webinars a month on different topics. You can sign up on our website to get notified about the webinars. At the end of this webinar, we'll send out a few things. This PowerPoint that you see on the screen, our E-2 visa guide, which is a comprehensive guide regarding E-2 visas, and a link to where you can sign up for additional webinars. My name is Kelly LeGrand-Wiener, and I'm the managing attorney at Scott Legal and will be the presenter at this panel today. I've processed hundreds of E-2 visas over the years, and I'm very familiar with the visa process. If you have any questions throughout the presentation, please add your questions to our chat box or the Q&A, and we'll make some time at the end to try to address those questions. Finally, this webinar will be recorded and will be made available on demand. So now we will get started with the presentation. All right, so let's get started by talking about the E-2 visa requirements. So the first requirement is that you must be a national of a treaty country. So E-2 visas are only available to countries that have a specific treaty with the United States that allows them to get this visa. The next requirement is that if you're going to be an E-2 investor, you need to own at least 50% of the E-2 company. If you're an employee, then treaty country nationals must own at least 50% in the E-2 company. There must be a substantial investment, and we'll talk a bit more about what substantial means, in the later in the presentation. But for your investment, there must be a legitimate source of funds, so that the money must come from somewhere that you can show that it's legitimate. For example, if you have personal savings from your employment, you'd include your tax returns and proof of you transferring the money. Let's say you sold a property, you could include the purchase sale agreement and proof of getting those funds. So the funds that you invest must be at risk and irrevocably committed. And what this means is the money must actually be spent. It's not sufficient to put money in a business bank account and say this is invested. It actually does need to be spent on relevant expenditures to start up your business or to purchase a company. And that's kind of what it means to be at risk and irrevocably committed. So if you're starting up a new company, then typical expenditures, which we'll talk more about later, might be inventory equipment, website, office supplies, commercial office space, any marketing you do for your company, if you need to incorporate in the US, all of those are typical E-2 expenses. And your typical E-2 expenses will depend on the type of business you're starting. So you need to spend a substantial amount related to the type of business that you are starting up. If you're purchasing a business versus starting a business, it might be a bit different. So if you're purchasing either a running business or perhaps a franchise, then what's substantial is often going to be kind of what the fair market value of the business is as has been offered on the market. If you're purchasing from a relative, that's a bit different. Then you may want to get an objective third-party valuation. But if you're purchasing from somebody where it's an arm's length transaction, then you'll be purchasing that business at the fair market value. One caveat with business purchases is you do have the ability to use an escrow arrangement. So although the E-2 requires that the money be irrevocably committed and at risk, for a business purchase, if you put the money into escrow and you sign a purchase sale agreement saying all conditions have been satisfied except for the grant of the E-2 visa, and the money will be transferred to the seller once the E-2 visa is approved, or transferred back to you if the E-2 visa is denied. That's one way that you can do an E-2 visa and kind of hedge some of the risk by using that escrow arrangement, if the seller of the business is open to that. Moving back to the E-2 requirement, another requirement is the business cannot be marginal. So the business must be able to support more than just the investor and his or her family. And what this translates to is hiring U.S. employees. So you must show that the business will be able to hire U.S. employees if it's a startup, within a 5-year period. If you're purchasing a running business, the business ideally should already have employees that you plan to continue, when you take over the business. Another requirement is that the business must be real and operating. This means if you're purchasing, again, a business that's already running, you can show tax returns, you can show invoices, proof that the business is actually conducting business activity, that it has employees. If you're starting up a new business, then real and operating means that the company has to be ready to start operating after the E-2 visa is granted. So in those cases, maybe you've signed a commercial lease, you set up your business bank account, you created your website, you've signed contracts, with clients or customers, you've acquired all licenses you need to operate. So that's kind of, where you really need to be at the stage where once you get the visa, the business is really ready to start running. So that's what real and operating means for a startup. Another requirement is that you will develop and direct the enterprise. So, the E-2 visa is not for people who are interested in passive investment. It really is for people who are interested in coming and actually, developing and directing the enterprise. So normally this is shown by at least 50% ownership in the company. That gives you the ability, as a majority or equal owner to, develop the enterprise. Additionally, they'll look at your background to determine, do you have kind of the skills and the skill set to actually run this type of company that you're planning to run. And finally, the E-2 visa is a non-immigrant visa, which means that you do need to show you have an intent to return to your home country upon the expiration of that visa. There's quite a low standard for non-immigrant intent for the E-2. You don't need to show that you have a foreign residence you don't intend to abandon, but you do need to, usually what you'll submit is just a signed statement stating your intention to depart upon expiration of the visa. This doesn't prevent you from renewing the visa, and in fact, E-2 visas can be renewed indefinitely. There is no limit on the number of times you can renew them, as long as you continue to meet all of these requirements. All right, so let's talk about kind of who can apply and how long the visas can be granted for. So, as mentioned in the previous slide, E-2 visas are only available to treaty country nationals. So there's, many different countries that are treaty country nationals, many European countries, such as the UK, France, Spain, Belgium, the Netherlands, and other countries as well, Australia, Canada, Chile, Colombia. Recently, New Zealand and Israel were added, and there's a very long list, that you can look up to see if your country is on the list. Unfortunately, India and China are not on the list. Grenada is a country that's on the list, and there are some times where, nationals of other countries may get citizenship in that country and may use that to then apply for the E-2. So that is, another possibility. It's not based on where you're born, but where you're currently a citizen. So in terms of options for obtaining the E-2, you can purchase an existing business or you can start up a new business in the United States. And visas can generally be granted for up to 5 years. There's many countries where you're allowed to get the visa for 5 years. Canada comes to mind, London, Spain. Whereas there are other countries where you'll get a lesser amount of time. And that's based on kind of the visa reciprocity agreements between your country and the United States. So for example, France used to be able to get E-2 visas for 5 years, but recently that was revised and now visas can only be granted for 25 months. And there's some countries as well where the visas are granted only for 3 months at a time. The visa, though, is an entry document. It's what you need to enter the United States when you've traveled internationally. And once you enter, every time you enter, whether you have a 5-year visa or a 3-month visa, you will be given 2 years in E-2 status. So if you enter on a 5-year visa, you would still be given 2 years in E-2 status, and then you would need to travel internationally again to get another 2 years when your 2 years is up. For people who have a 3-month visa, particularly if it's a single entry visa, They may get 2 years, work on the business, but then they would need to go back to a consulate and get a new visa anytime they wanted to travel internationally after that 3-month period. All right, so how much investment is enough? There is no set minimum amount, but the investment must be substantial in light of the business you are starting. So, for example, a service-based business like a consulting firm or a law firm would have a lower startup amount than, say, a car manufacturer or a restaurant. For those types of businesses, there's large fixed costs to get things, up and running. Whereas for service-based businesses, there's really not those same costs. So for lower amounts, and when I say lower, I really mean anything, under 200,000 or 150,000 is going to be considered low. So for these lower amounts, you want to be able to say you've spent 100% of the cost to set up the business. So you want to consider what are reasonable startup costs for your type of business. What do you actually need to start operating? So for example, if you're starting a restaurant, obviously you need space for that restaurant, and that space has to be outfitted in a certain way so that you can run a restaurant, and you'll need certain licenses to be able to actually run that restaurant. So all of those expenses will need to be actually made before you apply, and are good E-2 expenses. If you are looking at kind of a lower investment amount and you're starting up one of those service-based businesses we talked about, you can sometimes include kind of market research or industry reports to help support that you've spent 100% of the cost to set up this type of business. You may also consider getting a letter from a CPA who often works with small businesses who can assess the investment and provide their opinion that the investment is substantial and sufficient to set up the type of business that you're starting. When we look at investment, there's a proportionality test. So how much money you invested versus what are the usual costs to establish that type of business. And the larger your investment, let's say if you're investing, if the startup costs are, 50 million, and you've invested 10 million, perhaps that may be okay just because of the magnitude of the investment. But for these lower amounts that we're really going to talk more about today, you really most of the time are going to be, or almost all of the time are going to be trying to show that the money you invested is 100% of the cost to set up this type of business. And I think that's really, really necessary when you have these smaller investment amounts. There are going to be some investments that are just too small. So, it's very common. We have people come to us and say, well, I'm starting a consulting firm and I really only need a computer and I don't need office space, and so I don't have any investments. And there's some investments that are always just going to be too low. So let's say, you've spent $5,000, it's just never going to be sufficient to start up, or to qualify for the E-2 visa. Generally, it depends. This kind of depends which consulate you're going to, but you want to kind of be spending. You want to be investing kind of at least around 60,000 and trying to spend close to 35 to 40,000. Even if you have a business where arguably you could just get started with a computer and a website and nothing else. All right. One other thing about the proportionality test when you're talking about buying a business is that the purchase price, is often going to be considered the fair market value of the business as long as it's an arm's length transaction. So I know I mentioned this earlier. But if a business is just being offered on the open market and you purchase for that amount, generally that's going to be considered the fair market value and a substantial amount. If you're purchasing from a relative or someone that it's not an arm's length transaction, that's going to be looked at and scrutinized more heavily. So for that, you're going to want to look at the financials, either have a CPA kind of opine on looking at the balance sheet and the profit and loss, what is reasonable, for the purchase of the business, or perhaps get an objective third-party valuation of the business to help support that you've really spent a substantial amount or invested a substantial amount into the business. All right, so let's talk about some strategies to deal with a low dollar amount. So, one thing to consider is what is the overall strength of the E-2 application. So if you go into the process knowing you're going to have a lower investment amount, you want to make sure that all the other aspects of the application are very strong to help account, for that issue. So for the real and operating, you may want to, especially if you're going with a consulting firm, you may want to have contracts with clients, letters of intent for people that want to use your services. You can also join local business organizations, such as the local chamber of commerce in your area, perhaps meet with them. Some of them are willing to write a letter saying, they've met with you and they're, excited about the business opportunity you're bringing to their area. If the company has already started operating, perhaps you are living abroad and you've hired some employees who are taking, if the company is already taking in revenue, or you're operating the company remotely, those can help show that, bolster that real and operating part of the application and the marginality part of the application. For marginality, to create a strong case, you want to have a strong 5-year business plan and potentially hire US employees. So it's not required to hire US employees before you submit your application, but it's very helpful. And if you have a low dollar amount, and if you have a company where there's going to be kind of already extra scrutiny, hiring a US worker before you file, paying them all of the money you pay to them can be part of your investment. And that's very helpful to strengthen your application. So let's look at these 2 examples. You're opening a business and the investment is low. You've already hired 2 US employees. The business is taking in revenue. You already have around 10 clients. So real and operating looks great here. It's clear the company is operating, but it's taking in 80,000, per month. You already have several clients. So, you've already hired employees. So marginality is essentially already met. So this is, although there's a low investment amount, it's very clear that you meet the other aspects that would show that this is going to be a viable operating business. So then let's look at example 2. You have a low investment amount. You don't want to invest any more money. You don't want to hire anyone until after your E-2 is approved and you come to the US. And it's understandable why people may not want to hire before, getting their E-2 visa. You want that assurance that you'll be able to run the company before, taking the risk. Unfortunately, this does significantly weaken the case. So parts of the, having a low investment amount, you really want to be accounting for that in the other areas of your application to make sure that it's as strong as possible. And so in the second example, this person really hasn't done it, I think, as much as they could to increase, the ability to get the case approved. And in the first example, you don't need to be taking in revenue already to get the case approved with a low investment amount. But, having those letters of intent, having those, letters from business organizations who are supportive of the business, and then also, having those industry reports showing you've spent everything necessary, those are very helpful. So let's talk about some common E-2 visa expenditures, particularly with low investment dollar amounts and high risk cases. It's very common. Clients will come to us and say, I just don't know what to spend money on. I just need my computer. It's a service-based business. I don't need much. So here are some, kind of common E-2 visa expenses, that are listed here, kind of discussing what you can spend money on. So, very common these days, every business or most businesses are going to need a website. You're always going to need some type of computer equipment, particularly if you have employees that you're hiring and you purchase equipment for them. That can also be an E-2 expense. If you have a business that requires inventory, you can use furniture, but again, only if it's used for business purposes. So let's say you get a commercial office space and you're outfitting it with a couch and, a refrigerator, like that's fine, as long as it can, reasonably be shown as being used for business purposes. If you have rented a home office and you're furnishing that, it's going to be much harder to include that. Home offices are generally not strong expenses and not regarded, in a good light by the consulate. Other things you can include: your business entity setup costs. You can include legal fees, anything that you pay to employees. We have a couple, specialty ones down here. So purchase of real property. Again, if you're purchasing, let's say that you're doing property management and you're purchasing a building you're going to rent out. that would count. If you're purchasing a home for yourself and you intend to work from there, that really wouldn't count. Anything that's really a personal expense is not going to work. Similarly, for a car or a truck, if you have a business that actually requires, like you have a food delivery business, you have a taxi service, you have a construction company, and you need a commercial vehicle, that can be included. But it does need to be clear in the application that it's for commercial purposes, generally meaning you'll need to insure it as a commercial vehicle, register it in that way, and it needs to be clear that it's required for the business. If you're saying, I need this car because I need to drive to and from work, that's not really going to be considered a strong E2 expense. So what are good versus bad expenditures? So on the previous page, we had a list of really good expenditures that we think are very helpful for an application. And here's a list of kind of the weak or bad expenditures that are really not, we wouldn't include them because we think they actually weaken a case. If you include a lot of these, the officer often will be displeased with the application. And if you already have a low investment amount, including weak expenditures to bolster that amount is not very helpful. It actually will weaken your case. So travel, except for extremely limited circumstances, we will almost never include travel. It's just not considered a good expense by the consulates. Similarly, hotel, meals, transportation, entertainment, expenses paid to, related parties. So let's say you own two businesses and, you pay your own business for some service. That's going to be considered a very weak expense when they look to see if the money is irrevocably committed and at risk. And you're paying just essentially yourself. If you're going between two companies you own, it's just not going to be considered a strong E2 expense and could just weaken the officer's opinion of the application. So let's talk about some, challenges and tips specifically for consulting businesses. We've done many consulting businesses as E2, so they can be successful, but there is definitely some things to keep in mind. So again, theoretically, a very low investment amount may be sufficient to start a consulting business. If you have experience in the field and you have a computer and you already have a website, you may be able to start just with that. However, for the E2 visa, you really need to be thinking about what can you spend money on, perhaps things you may not have spent money on, but you may not have planned to spend the money for a couple of years, but you spend them now because it's better for your application. So maybe you didn't plan to upgrade your computer equipment or hire an office manager yet, but you make those expenditures, you do that early. And the reason being that you want to increase your investment amount to qualify for the visa. We always encourage people to, make expenditures that are going to be helpful for them down the road. But you do need to invest, as we talked about previously, even when it's a low amount, you still need to be looking at, around 60,000 with perhaps around 35,000 spent as really, a lower baseline. When they say you have to be committed to successfully operating the enterprise, an investment of $5,000, they're not going to think that that's sufficient enough. You want the consular officer to have a strong impression of the application. And so you do need to show, that you've made a diversity of expenses, that you've spent, you've set up your business entity, you've, developed a strong business plan, you've, paid for a website, you've, paid for employees, you've gotten the equipment you need, you have commercial office space. These are all things that help the consular officer feel comfortable that you are actually committed to developing this enterprise and have really made a substantial investment such that you qualify for the E2. So, as listed here, there's things that you can do. Office space, you can prepay for 6 or 12 months. Sometimes you're even able to get a provision in the lease that says if the visa is not approved, that you can get some amount of money back. That can be very helpful, both to help you bolster your investment amount, but also protect yourself. There's equipment that you can purchase. As I mentioned, perhaps you weren't going to upgrade your equipment, but, until later, but you make that expenditure now because it's helpful for your case. Similarly with marketing, perhaps you only plan to have a very bare bones website, but instead you choose to, elevate your marketing plan, really move it up in time so that you can, have that substantial investment. And then also hiring employees. I think for consulting businesses in particular, hiring employees is a very good idea, because the concern that a lot of officers have is that the person wants to come into the United States and just operate as a solo consultant. And that's really not what the E-2 is for. The E-2 is for people who are going to develop and direct an enterprise that will support more than just the investor. So hiring those employees ahead of time can kind of give the officer comfort that the business really is going to operate as more than just one solo consultant in the United States. I think another good thing for consulting businesses is to have a, letters of intent. So, just really good to be able to show that there's already people that are interested in your services, and you'll have some runway to kind of earn the revenue that's represented in your business plan. So now let's talk about some E-2 challenges for real estate investments. I think, a big challenge with these type of cases is that most consulates and USCIS are going to scrutinize you more closely to ensure it's an active, real and operating company and not just passive real estate ownership. Because there are many people that kind of want to, they say, I'll purchase a house in the United States and rent it out. And that's just not sufficient to reach the level of real and operating for an E-2. Additionally, kind of flipping homes on a small scale, really viewed negatively, by the consulates. You always make sure you have the proper licenses, as real estate is often regulated. And sometimes what you can do is kind of combine different real estate services to make it clear it's an active business that's going to employ U.S. workers. So, real estate holding companies, like you purchase a home, you make an LLC and you purchase a home, in the name of the LLC. That's not going to be, sufficient. I think, things that you can do, things that have worked. So a real estate brokerage firm, a real estate management company, renovation or construction. And then, for house flipping, oftentimes we have clients that may start a property management company, and then on the side, they also want to do house flipping. That's fine. It can be contemplated in the business plan that the main service is going to be this property management, and house flipping will be part of the eventual business services. So that's some way you can do it. Additionally, if you're doing house flipping on a very large scale, such that the officer is comfortable, it's a real and operating enterprise, that may also work. But when we say large scale, we mean that, you purchase 50 homes and you're renovating those homes and selling them. So there really needs to be enough activity that you can hire U.S. workers, up to 3 to 4 U.S. workers by 5 years of operations. And, at that point, the investment is going to be very large. You're going to have to invest a lot of money to really do house flipping on a large scale such that it qualifies for an E-2. All right, so another high risk area for E-2s that comes up a lot are equity trading companies. So this type of business has very similar challenges to real estate, in the sense that you need to convince the consulate that you have an active business and you're not just engaging in personal trading for family and friends. This is also a very regulated industry, similar to real estate. So you need to be able to show you have the necessary licenses, or explain how your business structure allows you to work within this regulated industry. So similar to real estate, if you're doing it on a larger scale with large value, multiple clients, this is more likely to be accepted as a legitimate business. So, I think similar to real estate, where you want to just buy one building and place it in the name of an LLC, placing your stock portfolio in the name of an LLC is not going to work for the E-2. You should also try to have, client letters that go beyond just friends and family, and a really strong business plan to really show that the business is going to be operating. The business is going to support employees. The business is not just going to be something for you to kind of trade, for your own investments. All right. So let's talk about some reasons that can come up for E-2 denials, particularly with risky cases. So one is a low investment amount. as we talked about, previously in this presentation, there's many things you can do to try to offset the low investment amount, but there are some investments that are just going to be too low, and there are some consulates that are just not friendly to low investment amounts. Particularly, consulates that tend to see very large companies coming through where they may regularly see investments of millions. To see somebody come in and say, well, I've spent $20,000, that's going to be a very difficult case at certain consulates. So, a good thing about a denial for a low investment amount is that if you do have additional funds to invest, you can invest additional funds and you can go back and reapply showing you've invested additional funds. You can also try to address it in other ways, such as, getting the CPA letter, getting market or research reports to show, that this really is a substantial investment, but investing more, there's some consulates that are just going to require that you invest more. So other reasons, the nature of the business. So as we've discussed, there are types of businesses that are more scrutinized and more high risk, particularly consulting businesses, real estate, and kind of equity trading businesses. There's others that are high risk, but those are three that come up a lot, particularly, I think, consulting and real estate. The consulates always, when they see those types of cases, are going to have additional questions. So another reason, filing location or venue. So as discussed, some consulates just want higher investment amounts. For example, in the consulates in Japan, often they're seeing very large companies that are sending, perhaps, dozens or more E-2 employees. So those consulates are used to seeing high investment amounts. When they see lower investment amounts, it's going to be, a bit harder. So you do want to kind of, to the extent that you can, think strategically about venue, discuss with your attorney, and see kind of what's been going on at the particular consulate where you're filing and if they're more receptive to low investment amounts. Another reason might be if you have been running this type of business, like let's say you've been a solo consultant in your home country for many years, but you've never hired employees, and now you want to come to the US to do the same thing. For that type of case, we would recommend that you do hire an employee before you file, because if the consulate sees your work history, which they will as part of the develop and direct requirement, they may not really trust that you're going to hire US employees, even if your business plan represents that you will. So hiring those employees ahead of time can help head off that type of issue. So another, reason for a denial might be concern over whether the business will create jobs for US workers. That's always a concern. And again, something that can be addressed if you're willing to hire an employee before you file. Other things that can happen are issues with the adjudicating officer. You didn't meet the requirements at the time of filing. So sometimes officers are not very friendly. That's unfortunate, but it does happen. So if that does happen, you want to, as much as possible, be polite, ask what issue they had with the file. They will give you a denial notice at the end, but it's best to ask them because they may give you some insight into what they particularly found to be problematic, and that's what's going to go into their notes, and that won't necessarily make it into your denial notice that you receive. They don't have to provide specific reasons, but they might just have boxes they check. The other is you didn't meet the requirements at the time of filing. So going back to the requirements we talked about at the beginning of this presentation, if you don't own 50% of the business, or the business isn't 50% owned by treaty country nationals, or if your investment amount is just too low. We had a client who, applied on his own, spent $2,000 and put $98,000 in a business bank account. As discussed, some of these, that's just never going to be sufficient to be substantial, even if you can make an argument that your business has low startup costs. Once this person came to us, we advised them on how to make additional expenditures. They went back to the consulate and were granted their visa. So it is possible to, address some of these issues. E-2 visa adjudication, trends and topics. For the Biden administration and the E-2 visa, will the approval rate change? The approval rates really didn't change during the prior administration and haven't really changed during this administration. One thing that has happened is that because of COVID, less visas generally are being issued, but the approval rates have not ultimately changed for E-2 visas. Will E-2 visas be adjudicated faster? Unfortunately, because of the ongoing COVID backlogs, the answer is still no. E-2 visas and all visas are being adjudicated at a slower rate. So that is something that is ongoing, and hopefully will improve over time, but is still an issue. What happened to BAHA? So BAHA was the Buy American, Hire American Act that was implemented by the prior administration with the goal of focusing on, kind of protecting U.S. workers. What we saw there was a lot of, consular officers for E-2 employee applications asking why a U.S. worker couldn't do the job. And then also, trying to ask what made in the U.S. It's not a requirement that your investments all need to be made in the US, but it is helpful, for your application. BAHA has since been revoked, so is no longer, part of the adjudication process. But it's still good to keep in mind that, when you're making your investments, you want to be making some investments in the United States. That does help, I think, with just the perception of your case with the officer. So are consulates currently processing E-2 petitions? Some of them are. Some have really come back to a very good place with E-2 adjudication. So for example, London has started adjudicating E-2s again within a reasonable timeline. Canada as well, not nearly as efficient as it used to be, but still within a period of a few months. Unfortunately, there are also consulates that are having a harder time recovering from the COVID backlog and consular staffing shortages, also caused by COVID to an extent. And so there are some consulates that are just backlogged by even, several months or even a couple of years. So for example, Rome is extremely slow right now with E-2 visas. In Colombia, Bogota is extremely slow, really hasn't actively been processing these cases. So, it's important to kind of talk to your attorney about which visa or which consulate you're applying at to see where they are right now, because all the consulates, the timelines always kind of vary between consulate, but now they're, the variables are extreme. So it's good to know. Another option is to extend or change your status in the United States. If you have a B visa, you come to the US as a business visitor, to investigate E-2 opportunities, you may be able to just change your status with USCIS. When we talk about USCIS versus the consulate, prior to COVID, I'd say we pretty much always recommended applying at the consulate if possible, because you often can get a visa and be able to travel internationally for several years with that visa stamp. If you apply with USCIS, what you can get is a 2-year approval notice. That approval notice allows you to remain in the United States and work at your business. It does not permit you to travel though. And once you leave the United States, you'd have to go to a consulate to get a visa stamp to return to the US, and you would be submitting a brand new E-2 visa application to the consulate. So the consulate is not required to follow USCIS's approval. They don't have to take it into account at all. They'll be viewing your application as a brand new application. However, although I'd say previously would always push people towards consulates, USCIS is a viable option for many people, and maybe a good option even given these backlogs at consulates. So if time is of the essence, let's say you're here, maybe you are here as a student or something like that, and you want to be able to start your business quickly. Let's say you started it on OPT and now you need to, to transition the business to a work visa. A USCIS filing may be right for you, may be possible. One thing to keep in mind with USCIS is they do a very, very strict accounting of the source and trail of funds. So where consulates may be satisfied by, I'd say a lesser number of documents. Let's say it's personal savings from employment. You might include a year of tax returns and a couple of bank statements. USCIS will want to see a dollar for dollar accounting of you accumulating those funds, everything that came into your bank account, and then that money actually being spent. So there are pros and cons to each approach, and something you can certainly discuss in detail with your lawyer, depending on what type of source of funds you have. So some issues and complex areas that come up with E-2 visas. So one, do I have to hire employees before I apply for an E-2? You don't. It's not a requirement. However, as discussed previously, it is very helpful, especially if you're talking about one of these risky cases, particularly for things like consulting companies where there may be some concern that you won't really hire employees. Hiring employees can just head off that concern. But it is not a requirement. Other areas that come up, complicated source and trail of funds. So as I mentioned, for USCIS, they're going to do a dollar for dollar accounting of your source and trail of funds. That means that, if you're wherever the money is coming from, even if was gifted to you many, many years ago, you need to show exactly what the source was. So let's say that you have a parent sold a company, 20 years ago and then gave you the money and then you moved it into various financial accounts. If you're going to use that as your source of funds for USCIS, they're going to want to see the purchase sale agreement from 20 years ago, that taxes were paid on that money entered the bank account, and then the flow of money up until the current time. So it can be it's quite a comprehensive requirement for USCIS, and is something that if you cannot provide a full, clear source and trail of funds, they will deny you on that point. It is something where they're just extremely specific. Things that come up with source and trail of funds. So, loans, for loans, you want to make sure that the loans are not secured by any assets of the E-2 business. If they are, that's not acceptable for the E-2. Often if you're purchasing a business, if there's some type of seller financing that's using the business as a security, that's not acceptable for the E-2. Gifts are acceptable sources of funds, but you need to show where the money came from. You can't just provide a gift letter. If the gift letter is from a friend or a relative, you need to have them explain where they got that money, and then you'll need that dollar for dollar accounting of where they got that money. I do want to note again, that's just for USCIS. Consulates are much less stringent about what they require for this source of funds. So if you do have a complex source of funds, often going to be better for you to file at a consulate to avoid some of these issues. Other things, that come up a lot, E-2 visas for two investors. If you're doing that, that's fine, but the ownership does have to be 50-50. And, ideally the investment would reflect that. Ideally, you would kind of each invest a similar amount, and you could not have a situation where your two investors, one person is investing all the money and then they're just gifting part of their investment to the other investor. That's not going to work. Each investor needs to have their own source of funds. And if you want to get a gift from an outside party who's not your business partner, that's possible. So that's something to consider. Other things that come up are substantive changes to E-2 business after filing. So, for example, if you have a company and your plan is to kind of sell shares and change the ownership over time, you always have to remember that you need to continue to own 50%, of the E-2 company as an E-2 treaty investor. And, or treaty country nationals need to continue to own 50% of the company, and then you can become the E-2 employee, no longer an investor. So any changes to ownership should always be discussed with Immigration Counsel before you make them. Because even if you have a 5-year visa, if your company in year 3 falls below 50% ownership, that visa is really no longer valid. You should not continue to use it. Prior to that happening, you should discuss with your Immigration Counsel, perhaps go back to the consulate, see if you can get an E-2 employee visa, but it really switch to another visa. But you really can't fall below 50%. At that point, your visa is not valid. Similarly, changes in type of business. If it's a substantive change, let's say you were a wedding photographer and now you're starting a restaurant under the same LLC. So when you went to the consulate, you had a particular representation of what you were going to be doing, and your investment was substantial, deemed substantial based on the type of business you were starting. So you cannot just start a completely different line of business. If you're a wedding photographer and you decide you're going to add a new business line that's very related, such as starting a blog, about wedding issues, that's fine. That's not going to be considered a substantive change that would require some type of communication with the consulate or USCIS. The only type that, you really want to think, is the change in my business so so extreme that I really can't fold it in as kind of a new service line. And if it is, then, that's something where you'll have to go back to the consulate, you'll have to go back to USCIS before you start the new business line. Family business purchases, we discussed this a bit, previously, but this is just going to be scrutinized more heavily. If you're purchasing from somebody on the open market, it's much easier for the assumption that, this was that the amount that you're purchasing it for is the fair market value. If you're purchasing it from a family member, you really need to have some type of evidence to show that the amount that you're purchasing it for is, makes sense, is substantial in light of the type of business. So you want to look at the company's financials and just make sure that, the amount that you're investing kind of aligns with what you think the company is reasonably worth based on those objective documents. All right, so let's come to the end of our presentation, and we have a couple questions that have come in. Somebody asked, how many employees do I have to hire? Do I necessarily have to hire employees? So for the E-2, yes, you do have to hire employees. You don't have to hire employees before you file for your visa application, but you do have to have a 5-year business plan that explains that you plan to hire. We recommend at least 3 to 4 employees by the end of year 5. If you're applying with USCIS, they have a particular focus on ensuring that the owner, that the E-2 investor only is doing these high-level develop and directing activities. So for those cases, we recommend you show you're going to hire somebody in year 1. So it's clear that you are really going to be focused on those high-level activities, and you have other people doing the skilled labor of your business. So even though we do say kind of 3 to 4 employees by year 5 is the minimum, I think that it does, again, depend on the type of business that you have. If you have a very, intensive business that requires a large staff, you need to, hire, employees. To allow you to really run that type of business. So 3 to 4 employees might not be sufficient. It just depends on the type of business you have. So somebody asked, does the initial payment for the business have to come from the bank account tied to the LLC? Can I send money from my own bank account to buy an existing business? So if you're the E-2 investor and you're making the investment, it's okay to send money from your own bank account to purchase an existing business. That is acceptable as long as there's a source of funds that makes sense, for the E-2. If it's possible to transfer to your business bank account and make the payments from there, that's preferable. But if you've made the payments from your personal account, that is also fine. If I'm starting a business, do I have to prove I have experience in the field? Not necessarily, but it's helpful. To give you an example, we have, a client who, was in management for several years in the agriculture industry, and then started a passion project of being a wedding photographer and got an E-2 for a wedding photography business. So we kind of utilized some of this person's previous management experience to help explain why they would have the skill set to become an entrepreneur and start up their business. So you don't have to prove you have experience in the field, but if you don't, there should be some understandable narrative about why you're going to be successful in running this business. So for example, you may want to take a course, some type of business course or something relevant to the type of business you're starting up to show that you really have, put in the time to really be able to run this business. And this is particularly the case if you are a young applicant, if you're an applicant without much work history, or your work history is completely irrelevant to the type of business you're starting. I think those types of cases can be a bit more difficult, and you want to make sure that you're strengthening your case by showing an understandable narrative. If the company is an existing business, it's generating good income and already has a few employees, do we still need a business plan? Not necessarily. If you have, tax returns that show increasing revenues and profits, if you have W-2 showing you have a good hiring schedule, at that point, you may not need a business plan. Business plans are really, required for pure startups where, you're coming with just the plan and without kind of a demonstrated, track record. I'm currently living in Portugal, but I'm British and have a British passport. Is an E-2 possible? So for British citizens in particular, there is, a specific requirement that you show that you are resident in Britain. So they do take a holistic assessment. Let's say you lived in the UK your whole life, but then you moved to Portugal for 6 months, perhaps you can move back to the UK and still, be able to qualify. But if you've never lived in Britain, you're not going to qualify for the E2. That's specific to the UK. Other countries do not have that particular requirement, but that is the UK requirement. In terms of a consultancy, would I need a physical office? Could I just hire US employees that will be working from home / remotely? You can. I think there's something in the, in the FAM, the Foreign Affairs Manual, that specifically says no office space is required. So it's not required by law, but I will say that it does strengthen your case, and it weakens your case to not have some type of actual commercial office space. Since COVID happened, we have filed cases where there's virtual offices. You pay for a business address and a mailing address, and that's been acceptable. So yes, it is possible to hire US employees that are working remotely. That's fine. That's a fine setup for the E2, but having commercial office space does strengthen your case. 50-50 for 2 E2 visas. Do both owners have to work for the business? Yes. If you're each getting an E2 visa, the E2 visa is not for passive ownership. You must each develop and direct the business. Do the funds for the E2 business have to come from outside the US, or can it come from money attained from selling real estate you own in the US? It can come from money in the US. It's not a requirement that it has to come from outside the US. It just has to have a legitimate source. So somebody's asked, they own a Caribbean takeaway in the UK, manufacture and sell ready-to-eat food. Can you start a business where you outsource manufacturing, but will store and distribute the products? Can I also franchise? So, this is a very specific fact pattern. Yes, you certainly can start a business that will encompass any range of activities that, that makes sense and will earn revenue and be able to hire employees. You can, anything kind of you contemplate in your business plan, that's legal activity, you can do. So if you say, I'm going to, to start, start kind of a business where the US part of the business is going to store, distribute, and sell products, and franchising will also be part of our business model. That's completely fine. That's certainly something that you can do. Someone's asked if a DUI in the US will jeopardize your application. It's a complicating factor. It's something where if you do get a DUI when you already have an E2, your E2 may be revoked. And it's something that you'd have to address in your visa application. So it's definitely something to mention to your attorney, because you will need to address it in your application, and it can be an issue for getting the visa, or if you already have it, can be a reason for visa revocation. So we have reached the end of our presentation, and I want to thank everybody for their participation and their great comments. As I mentioned, we will make this recording available, and you will also get a comprehensive guide as well as a link to sign up for additional webinars. Thank you and have a great day.